we are focused on the protection of our fundamental human right to sexual freedom. Joining me today is Larry Walters with Walters Law Group. Larry is Woodhull's general counsel and has been for many, many years. And he is also a noted First Amendment attorney. Welcome, Larry.
Nice to be here. Thank you, Ricky.
You're welcome. So I wish we had better things to talk about today. But what we're here to talk about is Friday's decision in FSC versus Paxton. Larry, what was this case even about? What happened here?
Well, how this all got started was the state of Louisiana passed an age verification law requiring adult websites to verify the age of users before they got access to a website that was 33.33% harmful materials, or basically pornography. The law in that state did not allow the government to enforce the law, but only private citizens. In other words, you could file a lawsuit if you were somehow harmed by an adult website not verifying a minor's age or any user's age before accessing. It's very difficult to challenge a law like that, and there were some attempts to challenge it by the Free Speech Coalition, but because the government could not file any charges or enforce the law, there was really nobody to sue to try to get a ruling from the court. Texas followed suit, but went one step further and allowed the Attorney General to bring enforcement actions against any website that failed to comply with the requirement of verifying all users before access. And so they passed a law in Texas. The law went into effect, and it was quickly challenged by the Free Speech Coalition, by ALO, which is also known as Pornhub. Others teamed up with the ACLU and other law firms to file a constitutional challenge to this law based on the First Amendment and the Fifth Amendment to the United States Constitution, and Section 230 and a few other issues, other problems with the law. The district court, which is the lowest level court, the trial court in Texas, got the decision absolutely correct based on existing precedent at the time, and looked at this law and said it clearly violates the First Amendment. It's preempted by Section 230. It's vague, it's overbroad, it's a content-based restriction on speech, and rendered a lengthy, well-reasoned decision striking down and enjoining the law as unconstitutional. Then the games began. The case was appealed to the Fifth Circuit Court of Appeal, which is historically known as a pretty conservative circuit court. And the panel of judges in that case kind of went off the rails and rendered a decision upholding the law and reversing the injunction by claiming that the law was simply the same thing as requiring somebody to flash an ID before going into an adult bookstore. Those types of laws have been upheld based on what's called the rational basis test, which is a very low threshold test, and just about any law can survive it if there's any rational basis to think that the government's objective was legitimate. And the court looked back at prior precedent involving online age verification, a couple of Supreme Court cases that said you must apply a very high standard of scrutiny when evaluating those laws, and said, well, those cases didn't really get it right, or the parties didn't really properly litigate the level of scrutiny to be used in evaluating a law like this. And so we're just going to uphold it on the basis that it satisfies the rational relationship, rational basis test, and invalidated the injunction, allowed the law to go into effect. People started getting prosecuted by the AG in the form of fines, civil fines and penalties. One of those cases was settled. Others were kind of just left in abeyance while the Supreme Court considered whether or not this law is constitutional. So that's how it ultimately got up to the Supreme Court, from initially the District Court, then the Fifth Circuit Court of Appeal. Finally, the U.S. Supreme Court granted review They only do that in about 1% of the cases, but they did in this case because it was a very important decision. And the legal community pretty well agreed that the Fifth Circuit got it wrong, that there's no way that that could be the proper test for an age verification system for online age requirements that imposes a burden on all adults. Anybody who wants to access sexually oriented speech would have to show their papers and essentially reveal their identity, give up their privacy rights in order to access constitutionally protected content with respect to adults. Adults do have a First Amendment right to access pornography or sexually oriented speech. However, the Supreme Court had not spoken on that issue for about 20 years. And we obviously have a different court now. And so nobody really knew what was going to happen. But that's how it made its way ultimately to the Supreme Court. And that's the decision that we're here to talk about today.
You say rational, to apply a rational basis. And you have to look around today at everything going on in the world and think rational according to whom, which is always the problem, right? By the way, for those of you watching, if you have questions or comments you want to share, just put them in the chat and we'll try to get to everything before the program ends. Now, Woodhull was involved in this case. And I have to stop here and do a huge shout out and a thank you to Corey Silverstein from Silverstein Law and to Brad Mitchell from Mojo Host, without whom our participation in this case absolutely would not have been possible. So thank you to both of you on behalf of Woodhull and on behalf of Larry. But Larry, what was our role in this case?
So once the Supreme Court granted review, we knew that we were going to get a decision on this issue. And Woodhull submitted what's called a friend of the court brief or an amicus brief in support of the Free Speech Coalition and the appellants who were challenging the law. That brief primarily focused on the difference between flashing an ID at an adult bookstore and tendering age and identity verification online. It's a very significant difference, and we wanted to point out, all the ways that someone's ID or their age or their contact information could be leaked or hacked. What is the result of giving some service your ID or providing information that allows you to be verified to access this content? And we demonstrated that a lot of people don't have IDs, number one. Not everybody has the ability to simply tender a valid ID card to get access to constitutionally protected speech. That even if you do decide to give up your privacy right to get access, that information is often leaked or hacked or could be used to extort people, particularly sensitive information like this, which is the name and ID of a person seeking to access sexually explicit content. When you think about how valuable that could be to somebody who wants to extort or engage in ransom. I'm going to disclose all the adult websites that you've ever visited and what you watched and how long you watched it, unless you pay me 100 Bitcoin. That kind of stuff happens and is more likely to happen if people give up their ID in order to get access to adult websites. And so we pointed out that significant burden and how different it was than flashing an ID at an adult bookstore where there's no record of the ID. The ID or information is not kept or maintained anywhere. There's no way it's going to get leaked in the process of showing it to the clerk. A much different situation. We were talking about the burden of disclosing your identity to some service in order to get access to a website. There were other briefs filed in support of the appellants, one in particular by ICMIC, which is a child protection organization that illustrated why it's actually more harmful to children to adopt a law like this and enforce it, in that children, minors who are looking for this content online, they're not going to just stop looking for it, all right? They're going to go somewhere else, and the somewhere else are going to be unregulated sites that aren't complying with the law, that are more dangerous, that can make children more vulnerable lead them down paths that are you know, harmful to the children themselves once they get on the dark web, or expose them to CSAM and other things that ultimately is more harmful to children than beneficial. There were, like I said, a number of amicus briefs filed. Everybody really raised the right arguments, I would say. All the proper evidence was put in the record, arguments were made, and I think most legal observers expected the Fifth Circuit decision to be reversed because they applied the incorrect standard. Again, this rational basis test, when all the prior case law, including US Supreme Court case law, required that type of law to be evaluated by what's called strict scrutiny, which is the strictest test, as you can imagine. It's called strict scrutiny. It's the hardest test for any law to pass. And the vast majority of laws that have ever been subjected to that type of test have been invalidated. And that was the nature of the discussion during oral argument, as to whether strict scrutiny should be applied or whether the Fifth Circuit got it wrong with the rational basis test. And so then we waited after oral argument, for months for this decision, and we ultimately got it on Friday. And boy, did we get it! Inexplicably, to a lot of people that reviewed the decision, the Supreme Court upheld the law based on intermediate scrutiny. Now, we haven't used that term in this discussion, and really the parties didn't use that term in the briefing, or at least much of it. Nobody seriously argued that that should be the standard, but seemingly out of nowhere, the Supreme Court created a new test for the right of an adult accessing content that is obscene as to minors or harmful content, for our purposes, pornography, and decided that there's no First Amendment right to access adult content without age verification. And therefore, the law is constitutional and can be enforced under this intermediate scrutiny basis, which none of these laws had ever been subjected to before. Justice Thomas struggled a bit with the precedent and the prior cases, trying to distinguish those cases. There was some discussion about the fact that the internet has changed substantially in 20 years, that a lot more minors have cell phones or ready access to the internet, and therefore can be exposed to harmful content easier, more quickly, more extensively. But ultimately, the court looked at some other cases that applied intermediate scrutiny, which has been used in other types of cases, particularly in expressive conduct cases. So what's that?
What is expressive conduct?
Expressive conduct, burning a draft card, burning the American flag. On its face, it's activity. It's not really a spoken word. It's not media. It's not a video. It's somebody going out and doing something, but with a clear intent to express a message, right? When you're burning the American flag, you're not, keeping warm typically. You are sending a message, an anti-American message. Or burning a draft card, you're protesting then the war in Vietnam. And so the courts have applied intermediate scrutiny to this expressive conduct, which is not speech. But here, the court was dealing with speech, pure speech. And what the court did is they tried to disaggregate the activities that occurred in trying to get access to the speech. One part of it is attempting access without age verification, which is unprotected according to the court. There's no speech protection or First Amendment protection when you are trying to initially access adult content without age verification. And then the speech that comes later. So the court said, well, it's reasonable and it's rational for the government to require this age verification at that point because no speech is occurring yet. It's just conduct in attempting to access speech. It's essentially a judicial magic trick to try to uphold a law that they wanted to uphold, but that would not pass the strict scrutiny test. But now we're left with this sort of conditional right to access sexually explicit speech, and a new test that the court, has applied in this case, and theoretically could apply in future cases.
So in effect, among other things, the Supreme Court has now rendered children less safe than they were before in imposing this new criteria that ultimately will probably do what the Supreme Court wanted it to do, and that is drive people off the internet.
Yeah, I'd agree with that. I mean, children are less safe for all the reasons that were laid out in the ICMIC brief. They'll be driven to other portions of the internet without age verification and encounter harmful material, harmful people, harmful conditions. You're not going to stamp out, the desire for human sexuality by imposing age verification. And as far as adults go, you are burdening their access to protected speech. Nobody disagrees that this harmful content as to minors is perfectly 100% constitutionally protected as to adults. And adults now have to give up their right to privacy in order to access constitutionally protected speech. And therein,
didn't the Supreme Court, weren't there two cases that said that you couldn't take away the rights of an adult to protect children? Probably a poor legal summary, but weren't there two cases from the Supreme Court that did that?
That's exactly right. And that's why the legal observers that looked at this, largely predicted that those cases would control because they were from the US Supreme Court and they dealt with access to sexually explicit speech on the internet. One was the Communications Decency Act case, which basically prohibited all indecent conduct or speech on the internet. It was an early internet case in 1997. Unanimous Supreme Court said, no, the government can't do that. This is far overbroad. And this court in Paxton dealt with that case by saying, well, that case dealt with a ban on indecent speech, and therefore it's different because one, here in Texas, we're talking about harmful to minors speech, not all indecent speech, which is a broader category. And also in the Communications Decency Act case, it was an outright ban on accessing indecent speech. Whereas here, there's no ban theoretically. You just have to show your papers and give up an ID and give up your right to privacy to get access. So that's how they dealt with that case. The second case involved the Child Online Protection Act, COPA. And that one was tougher for the court to get around because that case actually did involve something very similar, a federal law that required age verification, and you could not access adult content if you, as a website operator, required age verification. Then you'd have an affirmative defense to any charge under COPA. And so they basically imposed a type of ban, no access to harmful content, but you get an affirmative defense if you used age verification. And the court said, well, that also was a ban because you only got an affirmative defense if you used age verification, as opposed to requiring age verification as an obligation under the law and an element of any claim by the government against a website operator. So they're really parsing, very fine hairs here in terms of trying to distinguish those cases. Justice Thomas also tried to distinguish the COPA case by claiming that the parties never really argued what the proper level of scrutiny was in that case. And they just assumed that it would be strict scrutiny. Well, they assumed it would be strict scrutiny because that's what was required by First Amendment jurisprudence for the last 50 years. Any case like that was subject to strict scrutiny. And so the parties didn't have any basis to quibble about the level of scrutiny in that case. They did all essentially assume it's strict scrutiny, and the court agreed. It's not like the Supreme Court said, well, wait a minute, we have to step back and first determine the proper level of scrutiny. The Supreme Court went along with the idea that strict scrutiny applied in the COPA case. So it was difficult for Justice Thomas to get around that one, but parsing parsing the fine distinctions in the law and the fact that the level of scrutiny wasn't in argument or it wasn't opposed by the government in the COPA case, the court found that it was sufficiently able to distinguish the COPA case and say this is a different age. The internet has changed. Those cases aren't binding, and the level of scrutiny for this type of law is intermediate scrutiny, not strict scrutiny, and thereby upheld the law. What does that mean? That means that age verification can now be required for adult websites, at least in Texas. There are different variations of this law, as you know. We've got 24 states that have passed age verification laws, right? And they're all a bit different. Some of them actually impose criminal penalties if you don't age verify. Some of them require notarized consent from everybody in the depictions. Some of them require re-verification on an hourly basis. So there are some that may go too far based on this court's ruling, but it certainly does make those other challenges more difficult to pursue now that the court is prepared to uphold one based on intermediate scrutiny.
So let's say Texas is done now. The Supreme Court has ruled, the decision is in place. So there are 23 other states or 24 other states with various types of laws. How long does it take? Let's say there's a challenge. How long does it take before each of those states can get all the way up to the Supreme Court? And what happens while that's happening?
Right. So the answer to the second question, what happens during the pendency, most of the challenges that have been filed against other age verification laws have been put on hold pending the outcome of the U.S. Supreme Court case, because all parties recognize that the ruling that was going to come from the Texas case would likely be impactful on the other cases. So now that this case has been decided, the judges in the other districts where these cases are pending are likely going to release that hold and ask the parties, what are you going to do now? That's happening, I'm aware, in at least some of the cases already. So essentially, the parties will have to make a decision. Do we continue to litigate? Are the laws that are being challenged sufficiently different from the Texas law such that they might not be upheld even under intermediate scrutiny? Or do the parties, dismiss the case, agree to, accept that the court has ruled and that there is not a viable challenge? That may occur in some cases. In other cases, the parties might decide to keep on fighting. It could take a while to get a resolution, but I doubt that any other of these age verification cases will go to the Supreme Court. The Supreme Court has ruled on this issue. Right. So, the Supreme Court's already rendered a ruling on this issue, and it's not likely going to want to render another decision on substantially the same issue. So it would really be just the appellate courts, the circuit courts of appeal, that would be the last stop for any of these other challenges if they go forward. Some of them may very well be dismissed.
So I'm going to ask you to look in your crystal ball. What is the thinking as far as states' rights or a federal law? Right now, it's a states' rights issue. We're fighting a couple of bills coming up on the national front, like KOSA, Kids Online Safety Act. Our opponents, our free speech opponents, are brilliant at crafting names that are very hard to stand against. Is this decision going to drive a national law, do you think?
It could. The federal government has expressed an interest in legislating in this area. In the Supreme Court case that we've been discussing, the government filed a brief, an amicus brief, on behalf of Texas, and essentially laid out what it thought was the proper standard and how the court should look at age verification. And the reason they did that is because they want to consider passing an age verification law of their own. Right now, there is no such law pending. It may come up in a future legislative session. And, that could be a good or a bad thing. There have been, bills that have been looked at. There's been some legislative language that's circulated. And right now we're left with, 24 states that have passed these laws. I expect a bunch more states will pass new laws now that the case has been decided in favor of Texas, because they won't be as worried about the law being struck down or having to defend it in court. So, we could end up with this patchwork of 50 different obligations to comply with age verification depending on where the user is, and it's administratively and technologically extremely difficult for any website operator to do that, because
Wait a
of
minute,
different.
it's where the user is, Larry? It's not
Exactly.
where the site is hosted.
Correct.
It's where the user logged in from.
That's exactly right. Because the idea behind these laws is to protect minors within any particular state. So it's the state where the user is logging on that's relevant in determining the compliance obligations. So website operators now are, in the position of already having to determine, of these 24 different laws, which one applies to each user. And in some states, like I said, you've got an obligation to re-verify once you've verified one. And then you've got the problem of people, traveling. They've been verified in one state, but then they go to another state which has a different type of law or different ID requirements. They then have to verify them again using that other state's law just because they're traveling. It's crazy. So there is something to be said for a federal law that standardizes the requirements. I always have concerns when expressing any positive thoughts about a federal law, because it could just make things worse.
Right.
It could make it more difficult and burdensome on everybody if the federal government got involved. But it would certainly standardize the obligations, because once the federal government legislates in an area, that typically preempts the states from applying their own laws on the same subject. So there is a possibility that the federal government could override all of these laws by passing a single age verification compliance statute, and then there would only be one to comply with. But the devil is in the details there, as far as how bad it would be, or the burden that would be imposed on anybody trying to access constitutionally protected speech under such a law.
Well, you brought me to a complete stop with that thought. Is there any way to protect children without taking away the rights of adults?
Absolutely, yes. And there has been such technology in place for as long as there's been an internet, and it's called parental filters or content filters. And the existence of an end user content filter that can be installed by a parent that doesn't want their child to access adult content, very easy to do. Most of them are free, and they're very effective at what they do in blocking sexually explicit content. And that is the existence of those filters is the reason that the U.S. Supreme Court has struck down prior laws, because that is a less restrictive means of accomplishing the government's objective. Installing filters, trusting parents to know what's best for their minor children is the more appropriate way to deal with this problem and this issue. And so, yes, children can be protected by their parents by the use of these filters. The argument has been made in this case, and in the legislative arena, that not enough parents are doing it. Okay, does that then mean the government has to take over parenting? That's a real concern if you allow the government to step in the shoes of the parent, just because somebody thinks the parent isn't doing enough of a job to raise their child. But yes, that is an option. There's a second option, and that's device-based filters, right? And so instead of requiring the website operator to parse out all these different state laws and come up with tools and identify each user, the user could be required to once signing up on a device, authenticating or creating a device, getting a new phone or a new computer, be required to establish their age through biometrics, through IDs, through transactional records, thumbprint, eye retina scan. A lot of the technology that's already in existence can be used to establish how old any particular user of a device is. And then that device would send a signal to any website that the user is trying to access that says whether the user is an adult or a child. And it would be very simple for website operators to block any minors attempting to access with their device.
Who holds that information, though?
It's typically stored locally on the device. There are other methods of trying to accomplish this, such as through the app stores. So if you sign up on an app store and you want to download apps and use those apps, the app store could theoretically ask for records or verification of the age of the user, and then any app that is used by that user would automatically recognize whether the user is an adult or a minor, and only allow apps to be used that are acceptable for minors if the user is a minor. So there's different levels at which verification can occur, but these states have chosen the most burdensome and the hardest to implement, the most complex to implement, by requiring each website operator to identify the age of each user.
Well, we have a recording, don't we, that says age verification is the backdoor to eliminating porn.
Yeah, and that has been, largely the suspicion of the adult industry and the free speech community, that the imposition of this burdensome compliance obligation is directly related to getting porn off the internet and not so much to protecting children. One of the reasons that the states are not very receptive to the arguments made about the danger to children or the effectiveness of end user filters or even device filters, that doesn't get them where they need to be, because that doesn't get adult websites off the internet. All that does is protect children or find out the real age of the user. If that's not what they're after, then they're not going to want to go down that road, but instead continue to enforce these burdensome compliance obligations that are ultimately designed to allow for less sexual expression on the internet.
Unless, of course, people want to go to Google or Reddit or all the places where porn exists, but it's not an adult website. I shouldn't say porn, I guess graphic images or...
That's one of the arguments that was made in this case. The threshold that triggers the compliance obligation is if the website has 33 1/3% or more materials that are obscene as to minors. How do you ever calculate that?
I was just going to say that.
By
And
pixels.
how do they define sexual content?
Right. That is defined by a pretty long-standing test that's used by the courts. It's a form of the Miller test. So there's an obscenity test to determine whether material is obscene and illegal for everybody, including adults. And then there's a version of that test that is used to determine if material is obscene as to minors. And so it's called the Miller test. And it's basically a 3-part test that looks at whether the material is patently offensive, whether it appeals to the prurient interest in sex, and whether or not there's any literary, scientific, political, or artistic value in the content. So that's the obscenity test. If you add on as to minors to each of those prongs, then you have the obscene as to minors test. But the bottom line is that most pornography, used as a kind of generic term, would qualify as obscene to minors under existing case law. There's a lot of edge material, NC-17 or hard R-rated movies that do show some sexually explicit content. There's certainly sex educational materials and sexual wellness materials, reproductive rights materials. A lot of that may or may not fall within that category. So it does make it difficult to determine, how much of this content is harmful to minors, number one, and how do we calculate that 1/3 threshold? Now, if you look at a platform like Reddit, you just mentioned, how are you ever going to calculate how much of that is harmful to minors in Texas? You have to look at every video and evaluate it for the purposes of having serious literary, artistic, scientific, or political value. And okay, check, this column, for millions and millions of images and video to ever get a determination whether or not the platform is covered by these laws. And the question then becomes: is it all material that is linked to the website as well? What if it's hot linked? What if it's embedded, but it's on somebody else's servers? Is it the web page? You count the number of pages, or do you count the number of images or videos? Text counts in some of these states, so you have to read the text and determine whether it has literary value. It's a fruitless pursuit and very difficult. And the parties to the case argued that renders the law vague, unconstitutionally vague, because nobody could understand how to calculate the threshold. And the court, essentially dismissed that argument and upheld the law.
Because it'll still have a chilling effect. And so you can still be charged. It's up to you to have to defend yourself if the state comes in and says, shut down your site. You have more than 33 1/3%, and we don't think that your age verification is sufficient. So shut down. You have to defend yourself, and in the end, you could prove that I have no idea how, that you have 33 1/3, less than 33 1/3% content that meets sexual content, but you're out of business by then. And that, I think, is the goal. It's not to be able to enforce it. It's really to be able to enforce everything out of business, to start this chilling effect. Well, what chilling effect around the First Amendment is special, correct? Or did I make
It is.
that?
It's treated very uniquely in the United States. So what is a chilling effect? It is self-censorship, essentially. If there is a law out there on the books that may in some way threaten you, even if there's an argument that law does not directly apply to you, you are going to censor yourself. If you're a website operator, you're going to not serve residents of that state. You're going to shut down the website in that state. You're going to impose age verification, perhaps, or change the content. Remove content so you don't have 33 1/3 arguably obscene as to minors content. All those actions are a form of self-censorship that you are undertaking yourself in an effort to avoid prosecution, even if you could win, because it's the ride is the punishment, not necessarily the conviction. And if you're talking about years of defending yourself in court, you're talking also about potentially millions of dollars down the drain, and a potential for conviction if some judge or jury disagrees with your theory, right? So most rational people, most rational business operators will instead mitigate the risks. They'll censor content. They'll shut down a particular state, users in a state, geo-block, or just accede to the obligations of the law, even if there's an argument that the law does not apply.
I have a question from someone that I'm going to kick over to you.
Sure.
The question is whether 2257, which I'm going to ask you to describe, could be seen as part of the government's long-term attacks on adult content and desire to make it impossible for adult content creators to continue in business.
There's been concerns that 2257, which is a federal statute that requires certain age documents to be looked at and copied and created before any adult performance can occur. Right? So if you're going to make an adult movie, you have to check all the creators' IDs. You have to get certain information from them, like their legal name, date of birth, their aliases and stage names. and the date of production, and then maintain these records in a certain way so that if the government ever wants to knock on your door and ask you for them, you can make them readily available. That law has been subjected to numerous constitutional challenges. The Free Speech Coalition, which was also involved in the Paxton case, litigated against the US government on the 2257 case. That case went on for, I think, close to 2 decades. It went just up and down and up and down. Ultimately, Section 2257 is likely unconstitutional, and it's unlikely that the government can enforce it. I say that because there's no nationwide injunction against 2257, but most of the law has been found to be unconstitutional as a content-based restriction on speech. Why is that? Well, when you're making a movie in Hollywood that is about athletics or trains or cars, you don't have to get these records and maintain these records. It's only when the subject is sex that you have to compile all these records and comply with these obligations. The court found that that was content-based. You're singling out sexually oriented content for additional obligations, and that's unconstitutional under the First Amendment. But that case involved only the Free Speech Coalition, its members, and certain other plaintiffs, and those are the only people, individuals, or association that are protected by the ruling. So theoretically, the government could go and prosecute another person that wasn't part of that case for violating 2257 obligations, and a court could rule otherwise in a different part of the country. But that is unlikely because since the case was decided, it's been years now, there haven't been any 2257 prosecutions or inspections.
Okay, we have another question. Thank you. Someone wants to know about erotic audio or story sites. How does the decision impact those sites?
Yeah, it's an excellent question. And this gets back to the difference between all these different 24 laws and soon to be probably many more. They all have different definitions as far as the type of websites that are covered, the percentage, and what content has to be considered as potentially harmful or obscene as to minors. Some of the definitions talk specifically about including text, and some specifically exclude text, and some are just broad enough to likely include text even if it's not specifically in the definition. So the short answer is you have to check each of these statutes to determine whether audio or text would be included. But I can say it is likely included in most of them.
So I do have a question from one of the viewers, but I wanted to go back to something you said. And it's about sexual content and really America's war on sex. And I'm not advocating for censorship of anything else. Let me say that up front. But I was thinking about some of the movies that I've seen lately and how if I had a young child in my home, I would be deeply concerned to have them watch some of these movies. But there's they're rated, right? Movies are still rated. But they're not restricted in this way because this is sex. And if it's about sex or sexual expression, for some reason, the government, we know the reason, the government steps in and regulates. I was also thinking when you were talking about parental controls, that for a population that generally declares that no one is going to tell them what they can and can't do with their children, they're appallingly content to let the government tell them what they're going to do in this case. That was just a statement.
Well, it seems to be the case. I mean, that there has been support for these laws in the legislative arena and by some factions of voters. there has also been loud criticism by free speech groups and child protection groups, and obviously the adult industry, but not only the adult industry. Anybody that cares about personal privacy, about governmental overreach, about the nanny state, and being told how to raise your children or what your views should be on adult content or human sexuality. These are deeply private and personal matters that we in a free society should all be able to make our own decisions on, without the government deciding how to raise kids or what content is appropriate for which minors. Interestingly, the Texas law included originally an obligation for any adult website to post in no smaller than 14-point font a series of anti-pornography statements on each website, such as, porn has been known to be addictive and it's bad for your health and it hurts your brain. So Texas actually wanted every website operator to have to post these statements, contrary to their own will and contrary to their own beliefs, likely, in order to comply with the law. And fortunately, all the courts that looked at it, the district court and even the Fifth Circuit, said that that is a violation of the First Amendment. But it shows you where they're coming from. It shows you the background, and then the subtext here is, we want this content off the internet. We don't want it just inaccessible to minors. We think it's morally bad, and we don't agree with your right to publish it. And so we're going to make it as hard as possible for you to try to comply with the law.
So you just gave me a thought. And for the person who asked about other countries, I will get there. You just gave me another thought, though, and that is, how will the government deal with the dark web and the sites that are offshore and not subject to the United States rules and regulations? Those are the sites that are going to be a challenge, correct?
Yeah, that is one of the biggest challenges. I will tell you that Texas has filed enforcement actions against foreign website operators. Texas takes the position that if you're offering the materials or the content in Texas, we can come after you no matter where you're located. There are some practical difficulties in suing and enforcing judgments against offshore corporations, offshore website operators. You've got to show the existence of personal jurisdiction in the United States, and sometimes you have to domesticate a U.S. judgment in a foreign court, which is a whole separate proceeding. So, it can be a heavy lift, but those website operators are not out of the woods merely because they're in a different location. I expect, states are going to take action against foreign website operators if they do not comply with these laws. And it can be, a very expensive and lengthy proceeding to try to defend yourself, even if, there's an argument that there's no jurisdiction in the United States to be able to enforce, say, a Texas law. But as far as the dark web, the government is not likely going to be able to have any influence on what happens there. And it's going to be a breeding ground for illegal activity and unlawful content. And that's where the minors are going to go, because they can't get access to regulated sites in the United States.
So I know we're almost at the end of the program, and I want to be fair to the person who asked the question a while ago. What is the situation around age verification in other countries?
Right. So as we were talking about, offshore operators, they have their own issues in their own countries, depending on where they're located. The United States is not the first country to observe that, maybe that we should impose age verification on adult sites. This has happened in other countries, even before the United States, and in Louisiana, the first state to pass the law a few years ago. This has been brewing in the EU and the UK and Australia and elsewhere for some years now. And I can tell you that in the United Kingdom, the enforcement agency Ofcom is taking action against over 1,000 adult websites and trying to enforce the UK law on operators throughout the world if they're offering content in the UK. Another agency in France called ARCOM is taking similar actions, conducting investigations. And, this is not the end, but the beginning of a new reality for adult website operators. They're likely going to have to comply in these other jurisdictions because there's no First Amendment to challenge the law in other countries. And since the US First Amendment, which was thought to be the strongest of any country, did not save adult website operators from application of this law, they'll likely be enforceable in other countries. Now, there may be other arguments that can be raised. Some countries like the EU take privacy very seriously, and maybe they'll get somewhere with challenges on that basis. This is happening all over the world, and it's really becoming more of an industry standard. There's some concern that the credit card processors that are essential for any adult website to make money and charge users, that the processors themselves will require some form of age verification, not only in the states where it's required, but potentially elsewhere or across the board. So things are changing. This is a new reality, and what I'd say to any adult website operators watching this, either live or recorded, is start taking this seriously if you haven't already implemented age verification in the jurisdictions where it's required, because enforcement actions are coming. A lot of them, I'm sure, were held off pending the decision from the Texas case. But now we're going to start to see some enforcement actions and more states enforce and adopt these laws. So it's something to get your hands on, talk to your counsel, make sure your site is compliant and has been vetted.
So for people who aren't connected to the adult industry or who perhaps don't care, they just won't go to a porn site, what's the danger here? I know where I see some things going, but I'd like to hear from you. Where do you think this could go next? I mean, we had a decision, the universal injunction decision. Where do you see this going? Potentially.
Sure. Yeah. Well, the danger is anytime you start chipping away at First Amendment rights, it's the slippery slope. A lot of people don't care about porn. Fine. But there's going to come a time where the government is going to try to censor or burden access to your favorite type of speech, whether that be on reproductive rights or guns or your hobby. LGBTQ. Absolutely. Those controversial types of speech are all potentially to be targeted by this administration or the next administration. The problem is when you have a Supreme Court decision that creates an opening and allows a law like this to be upheld, that type of case, that decision will be cited in future instances by the government and by other courts in upholding similar laws that restrict other types of expression that don't involve pornography or adult entertainment. We're really hoping, as First Amendment lawyers, that this case is more of an aberration, that it's as the ACLU said, the porn exception to the First Amendment, and that it doesn't go any further. This case only involves pornography, adult entertainment, doesn't involve other types of speech. But that is the concern. What other types of expression are going to now be subjected to intermediate scrutiny, which allows the law to survive much more easily in a legal challenge?
Well, as I said at the beginning, I wish we were here to talk about something pleasant. I want to thank you, Larry, for joining me this afternoon. Someone in one of the chats asked if we were saying that it was acceptable for kids to be harmed on those platforms, the dark web, but not on age-gated ones. And I can say emphatically, no, we are not saying children should be harmed anywhere. We're saying when you take away the sites that do follow the law or that do take care to protect minors, you only leave the sites that don't care. And that's what we're saying is dangerous.
Absolutely. And that's been the argument that has been made by the child protection organizations in this case and elsewhere, is that we all have an interest in protecting minors and stopping exploitation, stopping harm. Unfortunately, this law was not the way to do it. It has been upheld, and information is power. So we just want to try to get the information out there as to the decision, its impacts, and how it affects your constitutional rights. And appreciate the opportunity, Ricky.
Thank you, Larry.
Take care, all.
Thanks. Bye, everyone.